because your external lawyer is worried about you coming back and saying, you gave me wrong advice, I lost X amount of money, pay me back. That's what your external lawyer is going to be worried about. Your internal lawyer should be used in a very different way. You should be very clear with your internal lawyer that we want your input in these matters. It should be more about risk education. In my personal opinion, it's never the right thing to allow internal lawyers to sign off on a deal. I think the internal lawyers, again, I stress, this is my personal opinion. In my opinion, the internal lawyer's role should be to educate the business about the legal risks. But it should be a commercial decision whether you choose to take those risks or not. There is no risk-free contract, there is no risk-free business. It doesn't exist. So as long as you as a business are aware of what the risks are, it should be the business's decision to say, that's fine, we understand those risks, we'll take them. Now, you might have to back that up with adequate insurance, etc., etc. That can be done. But I think you need to really sit down with your lawyers and think about if it's always a case of they're always sort of pushing you down or acting as a sort of brake. Why is that happening? Is something coming up quite frequently as a problem? And if so, does internal education help? Often I've found, when I used to be an in-house lawyer, what I used to do is I used to sometimes go and sit an entire day with the production guys. I used to just go and sit there with them so that they would come and ask me questions, which often they would not feel comfortable doing, coming to my office and asking questions, because then people would think there's a problem. Whereas if you tell your lawyers to really integrate with the business, make sure they really get to know what the business does, how much people actually know about these risks. Because often lawyers tend to assume that you know, whereas actually, why should you know? It's all about communication really and setting the right lines.
Basically, some of the big companies, if you see like IBM, Accenture, etc., when you get into contract, they've got a printed contract. You are only expected to sign.
Yes.
It's totally, absolutely, nothing can be changed in that.
Yeah.
They say it's a standard contract which we have worldwide, blah, 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 that continues. Printed contract, they just bring you and they'll ask you to sign.
Yeah.
What is that? All this doesn't, nowhere we can really use all that what you have said it now. It's just one side. They just come and you need to sign if you want to buy this equipment. Otherwise, thank you very much. It's a, arm twisting.
Yeah.
What is that, what you can do in that scenario?
Well, you're right, it is arm twisting. It's bargaining position, you're absolutely right. And there's nothing that can completely protect you from that, unfortunately. I wish I could give you a magic bullet and say, use that and you'll be successful. It doesn't work. But what you have to, obviously, the reason IBM is coming to you is because you're providing something which is valuable to IBM. Why would they come to you otherwise, right? So fundamentally, you have to first of all think that, well, there is something that we do for IBM which they want. Maybe they can go to somebody else and get it, fine. But the point is they've come to you. So from that assumption comes the realization that you do have some bargaining position. Just because somebody tells you it's a standard contract, you can't change it, blah, 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 you don't have to accept that, If you think about it from IBM's point of view, they're a huge company, right? They're dealing with hundreds, sometimes thousands of different service providers. If in each one of their negotiations with each one of these guys, they start amending the contract, how much work would that be for IBM? So they're also trying to minimize the amount of work they have to do. The way I would address that issue is by narrowing down on 2 or 3 really key issues. Issues which you think, well, this is such a big problem that if we don't deal with it, this will cause us real financial damage. Or it will harm our reputation, or it will prevent us from doing our job properly, or you've not understood this. These are the things we should target. Don't worry about, jurisdiction. Don't worry about stuff like that. They're never going to change. They're never going to agree to law of India. And quite frankly, why should they?
Hi, my name is Eldos Matthew. We are managing getting outsourced work from US, UK, and other good countries. And usually we are getting the contract only through soft copies. That is, we are getting contracts signed and get scanned copies of them. And also we are giving the invoice the same way. We put it sign and seal and give them scanned copies. Usually we doing this get speed up the process of, the pre-process of the work. So do you think is that legal to getting paid and giving the completed work? Is any legal obstacles which come across when we are going for a court regarding the payment work?
So I didn't quite understand the question. Is there a big obstacle to what?
We are getting only soft copies of the agreement, and we are giving only the invoice, soft copies of invoice also.
You're only getting soft copies, yeah.
Yeah. Is that necessary that we need to get a hard copy of the contract, and we need to give a hard copies of the invoice as well?
Well, that depends on first of all, your own law. Like if you're you're a company based in India, so if there are certain local laws that require you for whatever governance processes, tax processes or whatever to have hard copies, then yes. As far as strictly pure legal is concerned, as long as you have a copy in recorded form, which is proof of what you've agreed or not agreed, that should be enough. I would say from an operational point of view, it might be good to have hard copies, but there are plenty of companies that work on the principle of being as paperless as possible and who only deal with soft copies of all sorts of documentation. So, and in India as well. So I would be quite surprised if you had to get hard copies in every instance. There might be some specific contracts you have to have hard copies for. But I would in the first instance ask, for example, your tax advisor if you need hard copies, and your local lawyer if you need hard copies to deposit anywhere, for example. The other advantage with having hard copies is that if you're ever concerned about litigation, it's much easier to have hard copies, which you can deposit in court. But that's obviously thinking of the worst case scenario. But so yes, just because there are you've got a very different risk profile there, which means that the client must also enter into a license to get the sort of protection that you normally would get as a licensor, as opposed to a provider of hosted services. If the software then, you've got the license then, so presumably they will operate it themselves. That assumes that there's a circumstance where they can operate the software without you going bankrupt, without you being in breach. For example, when you are in breach. So your company still exists, you're not gone bankrupt, but they decide that because you've not done your maintenance properly, they want to take the source code, walk away with it. So that's where you would need a license. So you've got to link all these documents together, your current hosting services agreement, or whatever agreement is they use to access your services, the option for the license agreement itself, and the escrow agreement. They all have to link together, and they all have to be consistent in terms of when the right to access the source code actually kicks in and under what circumstances. It is, at the outset, I would say, unavoidable in some circumstances. You will probably have to give them access, but make sure it's narrow for as few reasons as you can get away with. And if they can use it as a licensed software, you would also need to think about who actually maintains it then. And should you still have the right to provide maintenance for software, which presumably gets you some fees as well.
Yeah, right. So essentially convert it into a licensable structure so you can part with the IP and still get some money if they decide to walk away.
Yeah. Sorry, I'm happy. If you have any more questions, get a hold of me outside, no problem. Thanks.
We have a long-term contract, and maybe it is hard copy. We have a hard copy of the same, and we should be getting the work order based on that contract that we usually getting through emails.
Yeah.
Is that just legal?
Yeah, I mean, as I said, it depends on, you have to obtain advice from your local lawyers, because I'm not an Indian qualified lawyer. What I can tell you is that in England it would be fine. It wouldn't be a problem. I know plenty of companies which
that's what I asked, because difference between two countries, India and US, is that fine?
In the US also, I would have thought it's fine. I wouldn't see a problem with that.
Okay, thank you.
Sure.
Hi, Mr. Quick question about specific cloud-related idea.
About what, sorry?
Cloud-based services.
Yeah.
Right, so we have a platform that's in the cloud. Now, a couple of clients have asked for the source code so that, because we're a small company, so what happens if, we go out of business, for instance?
Yes.
So we have the escrow mechanism on that.
Yeah.
But there's still the, so ours is a white labeling service. Essentially,
Yes.
people take it and then use it.
Yeah.
So the question is that what do we do? We need access to the code. So the usual stuff is a non-transferable worldwide blah
Yes,
blah license.
yes.
Right? But I mean, what if the client insists on having the code, and essentially once you transferred it, you don't really have that much control.
Yeah.
Litigations in another country,
Yeah.
there's a risk. So essentially what I'm asking is, what's the risk profile on that? Would you recommend doing it, not recommend doing it, keeping some clauses around, and
Yeah.
so on?
Well, it's quite a complex question actually. There's a lot, just because a lot goes into it, and funny enough, it's something which I'm dealing with at the moment as we speak. The first question I would say is your client a financial services institution?
No.
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 Okay, if they're not, then the reason for them demanding the source code, first of all, is quite a bit diluted, because in the first case, it is generally financial institutions which are required because of regulation to always make sure they have access to the source code of any software which is provided to them on an outsourced basis and deals with core services. So if they're not a financial institution, I mean, sure, it is core to them, but in terms of saying we have to have it, you need to ask why do you have to have it. Now, going at it from the other side, there are several ways to deal with it. Clearly, if you provide something on a hosted basis to begin with, you can say, well, I understand that in certain circumstances you need to have access to the software and the source code. The first thing to ask is, under what circumstances? That's the first thing. From your point of view, you want to keep those circumstances as narrow as possible, as few as possible. So not, for example, that they decide to up sticks, go away and get somebody else to do the work. No, sorry. Things that are acceptable are, for example, you go bankrupt, or you are in breach of certain maintenance update obligations. Those are the acceptable circumstances. Now, once you reach those events, there are several ways to do it. You can have an escrow agreement, that's fine. The mechanism I've used currently with this project I'm doing is we've actually constructed a license option so that if certain things happen, your client has an option to get a license of the software. Because what you have to think about is that